Thank you very much for joining us for the last session on hot topics in international arbitration. This session will be moderated by Mr. Vyapak Desai, who also happened to share his birthday yesterday. Mr. Vyapak Desai heads the International Dispute Resolution This conference is also hosted and sponsored by
After the conference, everybody is invited to coffee at Starbucks across on Vyapak.
Mr. Desai heads the International Dispute Resolution and Investigation Practice at Nishith Desai Associates. He is also the co-chair of the MCI Council. Mr. Chaitanya Arora is a managing director at Secretariat Singapore and advises on all aspects of business valuation, damages, quantifications, mergers and acquisitions, corporate finance related matters. He has acted as an advisor to private and public companies, private equity funds and sovereign wealth funds. Mr. Devang Vyas, Additional Solicitor General, Gujarat High Court, is a senior advocate and has appeared in multiple matters against various corporations and is experienced in arbitration, company law and court related matters regarding environment. Mr. Devang Nanavati is a senior advocate with rich experience in both arbitrations and arbitration-related court matters, both at pre-arbitral stage, interim measures, enforcement and child proceedings. Mr. Kartik Balisagar is a senior managing director at FTI Consulting and leads the FTI's consulting, economic and financial practice in India and is currently based in London. He specializes in valuation issues in the context of international arbitration and complex litigations. He has advised banks, private equity firms, institutional investors, and other corporates in valuation matters across various industries, including financial services, oil and gas, pharmaceuticals, mining and technology. Mr. Sanjay Tiwari is the Vice President Legal of Go Airlines Limited and has experience in several joint ventures, business transfers, business reorganization, business takeovers, mergers and acquisitions. He has led larger, complex and technical litigations in arbitration as well as consumer and land-related matters. Prior to joining Go Airlines, he served as a Chief Legal Counsel and Company Secretary at Hindustan Oil Exploration Limited and Head of Legal at SRO Limited. Last but not the least, also one of our proud organizer, Mr. Nitin Mehta, who is the advocate at Gujarat High Court. He has a rich experience in not only in arbitration but also in diverse matters such as constitutional, criminal law and environmental proceedings. Thank you, Devang.
Thanks a lot. Thank you, everyone. And I think we were together studying at his home. Maximum number of time spent with Devang bhai is in canteen in Gujarat High Court. So this is the kind of introduction I would have given, but I guess they have done much better since I left Gujarat High Court. So their introduction was much better then. So thank you everyone for joining this session. The topic is hot topics in arbitration today. Now, obviously, it's a big landscape. This field of arbitration, since we all joined practice, has grown tremendously. When we joined the bar, maybe 20-25 years broadly between all of us, I think whenever we used to talk about arbitration, it was all about negativity. Since I think the honorable judges and everyone is no longer here, I may quote somebody I heard 20 years back when all the negativity was there in the arbitration field. And I'm actually quoting a senior advocate at that point in time, and he was asked what is going wrong with arbitration. And he very candidly said only two things, sitting judges and retired judges. So he said sitting judges don't hear the matters and retired judges are taking their time in arbitration. But we have come a long way since then. Particularly post 2015 amendments, we have seen people taking arbitration as their own careers. So we are moving much ahead, and the topics that we need to now discuss is beyond the mundane issues of seat versus venue or what is the jurisdiction and what is the process and things like that. So I think time has come where we talk about some of the hot topics internationally which are happening all over the world, and I'm sure India will face them soon. So first topic which we thought we will talk about is also very apt, particularly post-COVID era, for the reason that the adoption of technology in every field of dispute resolution, including arbitration, is tremendous. Nobody thought the speed at which the technology has come in as part of dispute resolution process. And arbitration, being flexible in its own nature, obviously gives a great amount of opportunity to imbibe technology in different sense, including artificial intelligence, including transcription, including virtual hearings, cross-examination. There are endless opportunities. So straightway going to Devang on this topic.
Just clarify which Devang.
Devang by Nanavati on this topic. In your experience for last so many years that you have practiced in different areas, including you have a lot of international experience on arbitration. Technology has always been part of arbitration, but now it has been even more relevant. Maybe can you give your perspective on how technology is becoming more and more relevant and how it can become even better for efficient arbitration process?
Good afternoon.
So, good afternoon or good evening to all of you. And just as Vyapak had said, I had expected 10 people to be here, but I'm happy that there are more. I will share with you two experiences, but before I do that, I must lay out the premise. Of course, technology is again a very vast subject. We've seen the advantages of technology. Though as a senior counsel and an advocate litigating in courts for all these years, I feel that in longish matters or final hearing matters, the flair of a counsel goes away if you're arguing on a Zoom platform or any of these other platforms. So I'm not a big fan of arguing long matters on technological platforms, but yes, in situations as we faced unfortunately, it comes in very handy, and the system of justice continued to move and did come to a grinding halt like many other things did. So in that way, technology was very, very useful in this past 2 years. But there are certain aspects of technology which are very helpful. For example, a lot of you some law students, some young lawyers, all of you come up with beautiful judgments that in our days, Devang, Vyapak, me, Nitin, we would have had difficulty in doing that because we would have to run through various commentary books, then hopefully have a resourceful library where we could have found those reporters and seen those judgments and then Xerox them, and then the counsel or the senior would say, oh, absolutely this is not relevant, and everything goes down the drain. And now you of course Google it and we are amazed that, oh, you knew this also, but then of course we realize that you don't know the first principle. But that's a separate matter. What I want to speak about is the need in context of Indian arbitrations. I'm not talking of international arbitrations. That the need for cryptographers or transcripts. Because I think it is very essential that we have transcripts. And I'll quote you a lighter example where perhaps this technology would have hurt and did hurt the concerned person. And the second example, why it's the serious one. The one earlier was told to me by the former late Attorney General of India, Mr. Ghulam Bahnuti. I'm sure you all must have heard of him. He was a very fine lawyer, and who, of course, then adorned the position of the Attorney General of India. So he told me once, I will not name the judges for sake of respect towards their position, if not to them. So he was doing an arbitration in London, where his nominee arbitrator was a former learned Chief Justice of India. The other side was having some English QC as the arbitrator, and the chairperson was a former Lord Chief Justice of the English High Court. First of all, the learned former Chief Justice of India said that he will reach London directly 3 days before because he wants to be there earlier for some personal work. He didn't show up on the day of the hearing. He showed up 1 hour late. Everybody was frantically searching for him in London. This is almost pre-mobile days, so I don't know if there were cell phones or not. Then, of course, the arbitration was settled between the parties. And so, at the first hearing itself, immediately upon meeting, and so the learned Lord Chief Justice of England, in deference to the Chief Justice of India, said that since you are so senior and former Chief Justice of India, please dictate the consent award or order, and true to our own selves as we do dictations or used to do dictations and the judges do, he started dictating, now forgetting that they are not stenographers but they are cryptographers. So he said, okay, take down. Now this would be taken down, this words itself. He said, no, strike that out. No, that's not correct. You say that. And he rambled and rambled and rambled. And then eventually, the next day when the award was finalized and published, the Lord Chief Justice of England thanked everyone and very sarcastically he said, a very special thanks to the learned cryptographers who made great sense otherwise out of what was tremendous gibberish. And that was the reflection that we cast upon because we were not used to cryptographers. We were not used to transcripts. Every word that an arbitrator or a counsel or anybody representing a party says at an arbitration and an international arbitration is transcripted. And whatever you say, then if you say something else in derogation to that, would be detrimental. And it so happened that I was part of a team that we did an international arbitration under ICC in London, under Indian law, where the chairman was Michael Wong, one arbitrator was Justice Sri Krishna, and the other was an English QC. And in this arbitration, the other side was represented by a very eminent English QC. And during the arguments, we felt that he made a concession in the opening statement. Later on, they tried to wriggle out of it. But thankfully for the transcripts, we were able to save the day. And in fact, the tribunal relied on that portion of his recorded in the transcript in the award. So, and it was a very, very heavy stake matter. Now you imagine this would happen in a non-transcripted arbitration. There would be no way to establish this unless the arbitrators had memory of them and they noted it down. Even then, probably in the challenge, the counsel would have said that I never made such a statement, and so on and so forth. Another example, very recently, I don't see Mr. Rohan Lav Kumar here, he was in the morning. He was instructing me in an arbitration, and the learned arbitrator, not with any malafides in mind, I would say, knowing him, he made open comments in favor of a party. That my equities lie here, my sympathies lie here, my empathy, I'm going to do this, I'm going to award this, this is for sure going in. You can't do this. If it was transcripted, now if the challenge comes, there is no way a challenge can be mounted against a former judge of a high court, because nobody would believe you. And a district judge or a commercial court judge is not going to have the strength, if I were to use the word, to go against this, because, and what it is, it's word for word. Nobody is going to lead evidence on this and prove it, being able to prove it. If there had been transcripts, people would be more careful as to what they say. Even counsels, as counsels we ramble on in arbitrations, we do whatever we want in courts, we get away with so much. Of course, Gujarat High Court is now a different ball game because we are YouTube live, and so that's a different matter. We are much on the watch, and I think that has brought in a lot of crispness, as Devang bhai would agree with me. He has to agree because the name is common, but apart from that, it has brought in a lot of transparency, both on the side of the bench and the bar. People are careful as to what we speak. The judges are careful because they know that they are in public view and they will be seen. And before, what could you do? You had only oral words that judge said this to this lawyer did this to the judge, and so on and so forth. Here, now clips get viral within 1 minute. And look what happened. This judge scolded this lawyer. This lawyer, look what he told the judge. You know, everything is live. So, I believe that technology and especially transcripts. Now, then the question comes of expenses. Because we don't have trained cryptographers in India, or are very few in Mumbai, Delhi, there may be some availability in a city like Ahmedabad. Stenographers are difficult with good English language. I mean, with some of the stenographers that we see now, if I dictate 2 pages of an opinion, I think it's easier for me to write it down. I'm an old school guy, I don't type it up on the computer, but even if I write it down, it would be easier than to do that because there will be so many mistakes. But notwithstanding that, I think an effort should be there from institutions like the MCIA and other institutions to provide and train good cryptographers and make a provision in their rules
to have compulsory transcription. And the best part was that every day evening, once the hearing was over, you got the transcripts, you got to see it, and you could formulate your responses to the other side's argument without worrying that during the hearing you missed something or not, you know. And it was very clear for everyone to see. So it is in this context that I wanted to make this point to begin with and to lead into a discussion that the need for transcripts, which eventually leads you to transparency, it leads you to more crispness in the proceedings, is absolutely essential.
Sure. No, I think definitely technology is part of every part of our life, and arbitration is no different. But Chaitanya, if I bring you on this for maybe a very quick response, you have seen arbitration both in India and now particularly in Singapore, and we have heard a lot about Singapore in the morning plenary session also. But maybe a very quick experience sharing on technology and adoption of technology in arbitration from outside India perspective.
Thank you, Vyapak, and good afternoon, everybody. Again, thank you for being here today. It's not so much of a response that I can offer, more than I can offer a validation to what was just said by Mr. Nanavati. I think, if I put it very bluntly, technology saved our jobs during the pandemic. We wouldn't be able to keep our household running if there wasn't the ability to work from home and to work on a Zoom call and to conduct judicial proceedings remotely. Mr. Nanavati mentioned a point about transcription being cost prohibitive. It is correct. It is true that as of now, the expertise is not locally developed to the extent of the scale that is required. There is more demand than the supply that exists locally. So often we find, particularly when arbitrations are seated in India and venued in India, parties have to engage foreign providers of this service, and that is quite expensive and naturally shared between parties. But in making those decisions, one must think about the offset that the cost element would be facing due to the efficiency brought in by that technology. If you compare the two situations, I mean, I've given evidence in local arbitrations where the arbitrators are practically dictating my evidence to the transcriber and correcting the transcriber as they write what I said in the understanding that they got. And that starts a debate where I say, no, I didn't say that, I said something different. They say, no, this is what we understood. If there was a transcription facility available, this debate would be avoided, and I think the cost in terms of the time that you save would be quite material.
No, I think cost is a pure function of efficiency. The moment you bring in efficiency, I think cost doesn't matter in my view. So, I think on the cost part also, at least I have come across now quite a few service providers in India itself who are not only providing virtual rooms but immediate transcription services as part of virtual rooms as well. And some of these costs are actually going down substantially. And the way technology works, we know what was available, a phone or something 5 years back today is hardly a matter of cost. Moving to the second topic, and technology is something we can discuss much longer, but we want to cover at least 4 or 5 topics today. So moving to the second topic and I think we are all reading in newspapers and in other law journals about this whole issue of appointment of arbitrators. Now, this may not be a hot topic outside India, but definitely we picked up this topic as part of Indian arbitration, world, because we have still not got the right formula on the appointment of arbitrators. There are huge issues. We talked about Section 11 taking 5 years for appointment of arbitrators. We talked about experts not getting appointed as arbitrators. We talked about fees, and there is a case going on Supreme Court on a day-to-day basis on exorbitant fees charged by them. They not giving awards getting challenged. So we have yet not got the handle on how to go about it. So maybe first let me get Sanjay on this. Sanjay being the in-house counsel at one of the largest airline company.
Hello.
Yeah, hi. and has dealt with this issue for several decades now. So Sanjay, how does this work from the day the dispute occurs, right? How do you think about the whole aspect of appointment of arbitrator? Because it seems to be that it starts from you, right? Because you are the first person to know there is a dispute and you have the contract in hand that you have to appoint the arbitrator. So how do you deal with this situation at the start of the whole issue?
Hello. So, good evening to everyone. So, let me start my experience as a in-house counsel. So, appointment of arbitrator under section 11(6) comes much later. But before that, a lot of things happen, and most things do not reach at section 11 stage. So, and once business heads or operation heads deliberate upon something do not get resolved, then it will be left to the in-house counsels and legal team to handle. Parallelly, there will be a lot of negotiations taking place, and it takes a long time to settle a dispute. Sometimes because of indecisiveness, sometimes very tough positions taken by respective sides. Of late, when matter is not going to be resolved, it will be entirely left to the legal department to handle. Sometimes, particularly with oil PSUs and the PSUs per se, if you are not able to resolve disputes, at the end of 3 years, immediately they will invoke arbitration just to save from limitation period. And then they will be going slow because they have another 3 years to appoint an arbitrator. So, in one of the matters, similar thing had happened, and we just flagged this issue in the very top level, this MD level meeting with one of the PSU, that we were about to close the dispute. Suddenly we have invoked the arbitration. So they responded that our legal had advised, because 3 years about to approach, partly we would have lost some claim on account of limitation, so we invoked arbitration. Then we took, and they also went very slow. 2 years gone, we took objection to arbitration that, by the way, you have other precursor to arbitration, did not exhaust, like appointment of expert or conciliation, it was not exhausted, it suddenly jumped to arbitration. So there will be a lot of indifference or slowness before we reach pressing for appointment of arbitrator, and this is one of the reasons why most of the corporates still prefer ad hoc arbitrations, because it gives a lot of flexibility that suits to their pace, and simply they are not ready to cope up with the very fast arbitration, because it requires a lot of appreciation of evidence in very limited period of time. So that is one, that is my experience. And once you reach at a section 11, there is a tendency, don't agree to the arbitrator suggested by other side. There is presumption that there will be sympathy or something from, so don't agree, that is the rule. Unless your counsel suggests strongly that yes, he is very, very credible arbitrator and we should go along with him. And as far as cost is concerned, again, it's a very pain point, and there are a lot of issues associated with the attitude, and that deals with the cost. So normally we keep silent when when court appoints arbitrator. The typical order will be very plain, saying that the fees will be decided by the arbitrator. Sometimes we pressing that it should also be recorded, it should get past the schedule, maximum to the schedule 4. Even if you get recorded, after 2 years, there will be breach of that limit, and with the consent of parties, it will exceed. Of course, there are a number of my learned speakers talked Afghan matter. A lot of 4 or 5 matters also been tagged. Only PSUs have courage to take this matter. Normally, other parties do not courage because of apprehension of adverse inference or something. They simply concede to the arbitrator's demand. That is what happens at the Afghan matters. So this is cost. And one more aspect I like to deal with on cost. Again, a lot of things is built in our attitude. Because when matters are listed for hearing for say 5 or 6 years, 5 or 6 days continuously, we are very apprehensive. We may not be, most times not be prepared to argue the matter for 5 days or 4 days. There will be tendency to take adjournment, or one critics, another critics, just drag it simply because one side or both sides are not prepared. And then it leads to cost of counsels, cost of arbitrators, fees of arbitrators, and it adds up lot of costs. So lot of costs gets added up because of our lack of preparedness or not adequate preparedness. So simply we cannot run with the pace what institutional arbitration requires. So this is one of the biggest reasons of preference of ad hoc arbitration.
Sure.
Yeah.
No, I understand, and I think this is a different perspective, right? And sometimes why ad hoc is preferred over institution, because companies are not ready to take the faster route of institutional appointment. That is one side of it, and the other side, even internationally, when we try and appoint arbitrators in foreign seated arbitration, there is something which is prevalent across the world, and we call it mafia, mutual admiration for international arbitrators. And it's a very small pool, so it's not that we have this problem. Maybe they have a different problem, we have a different problem, but Devang, you have experience on both the sides.
Yeah, couple of things. I mean, look, these are so broad topics that we could talk a lot, but let me give you again a few things that are in my mind. So one, most of you are very senior lawyers also, and some of you are very junior lawyers and law students or in the corporate world. So as you know, that first thing that we do, if we are good at what we want to, then in our first phase of life, we academically want to do well. We want to be recognized for our academic talents. That is our ambition. The second ambition is, I guess it's a lifelong ambition with most of us, is to make money. And so most lawyers, once they start earning, it shows in our clothes, in our watches, so we move from Sheffers and Parker to Montblancs and whatever, Dupons and Montegrappa or whatever is the fashion, and to Rolexes and Pateks and whatever you have. So that is our next ambition, and drive fancy cars, BMWs and what or not. So that is our ambition. Once that ambition is also saturated with most successful counsels, then you want to get into recognition. So you want to become presidents of Bar Association, you want to become president of the International Bar Association, you want to be the chairman of councils like MCIA or whatever, and then you want recognition in your field. You want designations and so on and so forth, and you want that recognition. Now, think of it from the perspective of the Indian scenario, that most of our arbitrators are retired High Court judges. Most of them have achieved academic, most of them have achieved positions because they were judges and used to sirens and chowkidars and shiristadars and police and protocol departments and whatnot and so on. So that is achieved. So the only thing that is not achieved, hopefully for most of them, is the monetary satisfaction. And so in their last leg of life, when they really earn, then their goal is, alright, per sitting, I'll grant you adjournment, no problem, there is consent, but let's meet. How many times we've heard it? We gather for a sitting. Well, what's the need of a sitting? Both parties are agreeing. They'll adjourn the goddamn arbitration. No, but we'll meet because there's a sitting fee, right? So I have been told that the Mumbai High Court now has a trend where they are appointing lawyers as arbitrators only. They are not going in for retired judges. Secondly, the Prime Minister says, and most political parties says, though I don't know how scrupulously it is followed, that post 75 no posts. At 62 you are not considered to be fit to head a High Court bench. At 65 you are not considered fit to continue on the Supreme Court of India. But at 82 or 88 you are fit to conduct an arbitration. So at the end of the day, these are factors which go against. I am not saying that all retired judges fall into this category. There always will be exceptions on both sides. But, and I don't say that lawyers will also not fall under this bad category. But at the end of the day, you need to think beyond, as somebody in the plenary session, one of the judges mentioned, that look for professors, look for eminent academicians, look for senior advocates, look for good advocates, look for good people, good counsels to become arbitrators. I don't know how young people will come into it. Maybe they can, but I think you will need at least 10 years experience to
then go on and decide, because otherwise it's too early in your career to sit. I think that till that time what I did, you become a moot court judge. But so you get some experience. But at the end of the day, you need to look beyond retired High Court judges. Unfortunately, as this word was used, it was of course a very strong word, the MAFA or whatever that mafia that we used. Let me use the other word for synonym for mafia, which originally was, which is the international brotherhood, if you want to call it. It's an international brotherhood of these people. At least in India, it is a national brotherhood which ensures that they are appointed, as only arbitrators. I think we need to move beyond that, and that will solve most of the problems if I can go from there.
Okay, let me jump from one Devang Bhai to another Devang Bhai on this. Devang Bhai, you have seen quite a bit of this from government entities, public sector, also on the private side earlier as well. But what's your take on this? Because 80% or maybe more, one of the parties is non-private party, right? Or a government or a public sector or something dealing with. And we keep talking about Arbitration Council of India, we keep talking about institutional appointings, Section 11, but nobody is asking them what is their take on this, right? Why are we not able to solve such a simple problem, which is not even a problem outside India? I know India is unique in every way, but what is going wrong? Because if 80% of the disputes, the party, we know who are the stakeholders. How do we solve this? What is the magic wand on this?
Vyapak, thank you so much from jumping from one namesake to another. A very pleasant evening to all the elite panelists here, the dignitaries of the dais, including the honorable judges. As I see, my Lord Justice Rao is here, and we adore him always. As also all of you, those who are into law, those who want to get into law, as also those who really have been either senior or junior to me. I would want to at the outset thank Vyapak, Nitin, Niti Sachdev, who probably ran out of patience, but now she is back there, and also the CEO that we had in terms of Madhukeshwar, who had a flight to catch, and I was told that he has left. So while I end up thanking these people in terms of organizers rather, I would also want to thank all of you. See, what happens is that when you are allotted last session, the crowd is already ruminated about the entire field, as also all the subjects. And they really have been very patient, either waiting for the high tea to happen, or probably waiting for elite panelists like us to speak up. So I would thank all of you for being very patient with us. Devang Bhai mentioned a couple of things. He mentioned about old school thinking, etc. While, of course, I am not old, I would not want to associate on that part. While I may not be a millennial or a snowflake, as you guys are very fondly call each other, I still continue to be a person who would want to go by the books, as also who would want to really go by the discipline that really has been instilled so deeply, which Devang Bhai, Nitin, even Vyapak will agree with me on, and we would want to really go by the books. It doesn't really make us old school. Of course, I'm just 45, so can't be old school. Devang Bhai also mentioned with regard to new lawyers being pumped into specialized, trained, and tenure experience. He's so right. Tenure is a benchmark which probably would give us some sense of accomplishment when we complete those tenures. At the same time, so is Devang Bhai, so is me, so are all others luminaries who really spoke before me. We all continue to be students. And exposure to all of us. It has also created, or rather has resulted into a situation where smallest of our faults or flaws are magnified, which has really left us open to scrutiny to be done by people like you, who I would want to very happily call as millennials or snowflakes, who really know nothing of law, would still end up telling us, ये सही नहीं था, ये ठीक नहीं किया था. Was stop judging. Rather, start gathering what you learn out of those YouTube proceedings. It is way different to prepare a matter while sitting in your comfortable chambers or in your home environment than to stand up and argue a matter before learned judges. If you are a teacher, you probably would be teaching children who know nothing, who at least have some acceptance that they are not educated and you are educating them. Boss, consider our job. Boss, we end up doing what wrong. And we have to argue before people who are more learned than us, who are more educated than us, and who are probably more even patient than us. It is very easy to argue half an hour nonsense than to be a judge and tolerate 7 hours of nonsense which really is being thrown at you. So they really perform a difficult job. But when it comes to arbitrations, should we not really be asking ourselves as to what are we doing? Our arbitrations, be it ad hoc, institutional has just started emerging post 2015. Our arbitrations otherwise have always been ad hoc, governed by earlier 1948, then 1996 Act. What are they ultimately? Are they really an alternate dispute resolution? No, the answer is they probably more or less are like retirement benefit program for a lot of people, including experts, judges, as also some lawyers who are otherwise out of quality litigation. As a litigating lawyer, I probably would want to give last priority to anything which is not fruitful. I am not really discounting arbitrations here. Something which is not fruitful. As Tushar in the first session, the plenary session, he is saying that there are two categories of people whose dates are most difficult to get. First, film stars, of course they are, minus the Gupta ads that they end up doing. And second is the retired judges when it comes to conducting arbitrations before them. What happens is, he didn't elaborate this. I or he or even Devang ordinarily would be arguing before a panel of 3 retired judges. What happens is that when it comes to next date, it would be convenient to do. One would say it is not convenient to me, he would come up with a date which may not be convenient to me as a lawyer, and so on and so forth. And that is how my views being anti-ad hoc arbitration are not just an imaginary situation. They are actually emerging out of the practical experiences that we really come across as lawyers, as also as litigants, because ultimately we will be representing litigants. So when it comes to those things, that is what probably starts making us take a shift towards institutional arbitration. Cost effective, this, that, etc. Glorified things. Fair enough. We'll really keep that in mind. But nonetheless, it doesn't really mean much. Now what means much is litigants' viewpoint on this. And as Vyapak posed that question, now I am probably after a very long preface coming to the question. He posed a question to me, that what is your view as a litigant in terms of appointment of arbitrators or even in general parlance? Private litigants, they always dominate the whole thing in terms of arbitration, because they are the ones who are seeking arbitration, one, to avoid that long litigation. Second is, they are the ones who would be naming their arbitrators. Now we at the receiving end, when I say we, please don't take me in personal capacity, not even as a law officer, we as government institutes, be it public sector undertaking, be it a department or be it government per se, we are ignored in a sense that despite the fact that we figure out in more than 85% of cases as litigants, we are never perceived as litigants. We are only perceived as a government body or a government entity or a public sector undertaking. And I don't know why that should really take us out of that equation. Then, આખી બધી જે પ્લીઝ ટુ પેશન્ટ તમે લોકો સવારથી કરો છો, કોઈએ ક્યારે એવો વિચાર કર્યો? I'm sorry for the Gujarati, all right, let me come down to English. So, you have been discussing the whole appointment procedure, whole aspects of arbitrations, etc., without really taking into consideration that the entity which contributes 85% towards that litigation, be it arbitration or the actual litigation, are government bodies. And don't you really think that our voice or their voice should also matter? It doesn't really. Under section 11(6), you will file an application that we want this. Now earlier, or now, we would, since we would want to make all of you end up signing dotted line contracts, as the Honorable Apex Court says, we would end up coming up with an arbitration clause which would name an officer or a designation. The Honorable Apex Court and Arbitrator say that nothing doing, we can't do it. Why? Because bias. They are rather transportized and corrected. Yes. So why? Because they are your departmental entities. They are biased. They are an interest. And it went on. We as government bodies still would enjoy that domain on field that governs the contractual aspects. And therefore we wanted to come up with our panel of arbitrators. Even Honorable Apex Court considered that. And they said that if an arbitrator doesn't have a personal interest in it, fair enough, out of that panel we'll end up appointing. Why do we want, be it me, government entities or even private entities, why do we want our named arbitrators and why not the institutional arbitration? I would not say proceedings are rigged, I would not say proceedings are biased. Nonetheless, can you really rule that out? The answer is no, you can't. A party names an arbitrator. Should bias not really start begin from there itself, that very moment onwards? We naming an arbitrator, not acceptable. Party naming an arbitrator under 11(6) was more than welcome. Why this? The law really requires to undergo some change with regard thereto. One. Second, we are now not allowed. We can't name. Will not name. Thank you for the lovely ringtone. So we can't name. At the same time, the law as it stands today doesn't really talk of India when we talk of, I guess, that call for a repeat. So, what we really are looking forward to is amendments that have happened post 2015. Post 2015, we started as a statutory entity, started recognizing institutional arbitration. Like MCI, I would want to get associated with them in any capacity as I can. Today as a law officer, I would have my limitations, but otherwise I would welcome that idea. Why so? Cost effective. Second, free of biases. And third, credibility. That credibility was missing is what Honorable Apex Court found when it came to naming arbitrators either in the contract or when it really came to naming an arbitral tribunal. And therefore, say of those public bodies entities would really assume a lot of significance. And of course, you won't hear us, but then government will. Nonetheless, a stage has to come where our views are also, as in government bodies' views, are also taken into consideration when it comes to appointing arbitrators which are neutral, and institutional arbitration is the only way out, is the only answer. If you don't want our empaneled arbitrators, if you don't want our named arbitrators, let's settle for institutional arbitration. And this is how I would want to tell Vyapak that he has really...
Magic wand.
Yes. This is the magic wand that probably needs to be brought into service, if not statutorily, by practice. England doesn't really have everything codified. And we don't follow them despite 200 years of rule on us. We don't go by customary laws in all senses. We go by the codified law. Here, since there is no codified law, at least we, with the collaboration of all the parties who are litigating, more particularly in field of arbitration, we must really come up with some solution which is practically workable and which can later has a potential of becoming a custom, whereby we will end up really settling for institutional arbitration. And that is the magic wand that Vyapak probably wanted me to name. Now these views are very personal. Very, very personal.
I only wish it were not personal.
No, yeah. See, I may have been invited here as a law officer or probably in my capacity as a designated senior advocate. Trust me, the views that I express here are purely of Devang Vyas, namesake of somebody, surnamesake of probably nobody here at least.
If the media misquotes you, you can always say it was the other Devang who said it.
So let me change little gears and move little further. We have 2-3 very interesting topics to cover. So arbitration, as we all know, right? There was a worldwide survey done by some years back, Whitehead case, Queen Mary survey. They do on several parameters. One of the parameters was what is that one or two things why people choose arbitration over litigation. And a lot of people answered by saying confidentiality, because we don't want to go to court and now it's on YouTube. So confidentiality obviously goes for a toss, while arbitration still is considered at least a closed door event. But the other side of the survey also talked about what are the pitfalls of arbitration. And people said, because awards are not published, jurisprudence don't get formed. Today we don't know contract law after maybe 1950, 1960, the development of contract law is going slow for the simple reason that all the arbitration awards, who interprets contracts, we don't know what the kind of law is. So, and second, we want to keep it confidential. We don't want to, put it in public domain. But then we now have a law which says under the Arbitration Council of India, we need to even file. Of course, those provisions are not in practice yet or force yet, but we have to file the awards with the registry. Now, whether it will remain confidential or not, we don't know, because anything in India is available to media, right? So there is a whole debate of confidentiality versus transparency, and maybe Nitin, if you can give a little sense, because there is a worldwide debate as to whether these awards should be published or not, and India is obviously a little away from it, but Arbitration Council of India has come very close to at least registered awards. So Nitin, if you can share your views on what trumps confidentiality or transparency.
Thank you, Vyapak. You have put it in perspective, and let me really start from where it begins. The question today is that I see quite a few here who do non-lit work, who do drafting. Today, any commercial agreement, without even thinking, there is an arbitration clause. More so in international arbitration conference, in agreements. The question is why arbitration clause should be there or should not be there, should be part of a thought process. So what is the thought process? To actually put in an arbitration clause, the original reason why people wanted arbitration was because the parties were in different jurisdiction. One may be in India, one may be outside. So which jurisdiction would be chosen or where the seat would be? Forget party being one Indian, one foreign party. Even within India, one is from Tamil Nadu and second is from Punjab. Where who will bell the cat, which jurisdiction will have a say, though cause of action will be governing it. But then parties wanted independent adjudicator, and therefore the first reason why arbitration was chosen was because people wanted independent adjudicator rather than a party, a adjudicator from one jurisdiction relevant to one party. Second was obviously the courts in India and throughout the world. There was obviously a delay in adjudication. So the second reason for arbitration choice was obviously to overcome the delay, and assumably arbitration ought to have finished much earlier than what the court proceedings would. And third, the most important, as rightly pointed by Vyapak in the survey, and which was originally the thought process to put in the arbitration, was when commercial parties did not want their disputes or the evidences or their data to go outside the proceedings relating to that dispute, and therefore confidentiality was one of the very, very major reasons why people chose to put arbitration as a clause rather than going to court of law. Today, thanks to the fad, I would say so, in an arbitration conference, that without even applying your mind that a particular kind of a contract requires arbitration or not, we are putting it without considering the parameters required for it. Therefore, confidentiality definitely was one of the biggest reasons for putting arbitration clause. Now, let us understand why confidentiality. Suppose there is a tender which is floated where A and B are much in dispute, are always a competitor in floating that tender. B has a dispute with his subcontractor, which if goes into the court, the evidence will show the cost matrix of that B party, which will be then a public document and could be taken by his competitor A and then used in the next tender which is there. So we all understand why confidentiality under commercial agreements will be required, with every bit of percentage being fought over for purpose of profits and for getting an order. Third is again with respect to, so therefore arbitrations were put into place in commercial agreements outside India. The resultant effect was people, the countries, the destinations, jurisdictions wanted to be the most preferred jurisprudence in arbitration. So relatively what happened was the common law stopped being developed in international in other international countries, especially in England, where most of the commercial disputes went into arbitration with hardly any scope to appeal, and therefore the appellate court, which order would definitely be made public or would be available for review, did not happen. So there was a cry for transparency in two terms. A, that when as a judge or as an arbitrator, I come to know that my order is not going to be challenged, probably that effort or effort to be right slightly goes away, because when I know that what I say is going to be final. Therefore, more such awards which ought to have been challenged were not there for challenge, and such awards did not put the pressure required on the arbitrators. Secondly, as I told, that the jurisprudence was not developed because everything was ending at the arbitration level. Nothing was coming into court level as a precedence which can be later taken on. So the cry for transparency began. That the transparency in terms of disclosing the award, everything should be done, and there was therefore a conflict between confidentiality and transparency. Now, this is the international scenario which I just spoke about. Now, let us test it under Indian scenario. In Indian scenario, till almost 1940 Act and almost till 2015, 34 was considered in the mind of the judge and the advocate that it is equivalent to first appeal. That everything will be open for challenge, though the jurisdiction to really hear the appeal was reduced from every year, every amendment. Therefore, in India, there was no cry for transparency as most of the awards were challenged, and confidentiality was important, and the jurisprudence came to be developed because of the appellate orders, which was always open for everyone to see and comment upon. Now with 2015 onwards, the scope being again limited, there is a cry of transparency which is by the advocates, by the litigating parties also taking place in India. Again, the major reason being that, as everyone has pointed out over the entire day, that the arbitrators here predominantly are legal luminaries in form of judges, technical experts are not available, and therefore in a kind of a contract of construction where definitely I can tell you for sure a commerce background judge will definitely not be able to understand the nuances of a construction law and construction contract, and therefore such awards which are passed by someone who does not understand completely the science behind it needs to be challenged. And now, since the scope of challenge is not there, the question is whether such awards should be made public for two reasons. One being that their good awards may be then acting not as a precedence but kind of a probatory value. And two, though certain awards may not be eligible under section 34 by way of a challenge, but then there can be public criticism of that particular award, the nature, the way of that award being passed and the award itself, which in turn will definitely will help in the arbitrator's bar being raised. And therefore, the conflict between confidentiality and transparency is a live issue in India. Now, what does this was happening when in 2019 Section 43A came into play? Section 43A, as in the morning we have heard, talks about talks about confidentiality as a mandatory condition to be applicable within all arbitration proceedings, and only exception being enforcement of the award. That obviously it has been said that enforceability would even take out from its gamut section 34, section 9, everything of that sort. So therefore, a particular to arbitration, there are three things which are applicable. First being the law, the act which is applicable. Second, the rules which are adopted by the arbitration. And third, there being the agreement between the parties. Now, in various other jurisdictions, in fact, other institutional arbitration rules, the default position is that confidentiality, if nothing is said about it, it will be considered as confidential. While few of the ICC rules now are saying that as a default position, you are putting that it is the confidentiality will not be there. The arbitration awards which are not in terms of absolute private will be published unless parties apply for it not being published. Therefore, in India, the debate is there, and let us see. My views obviously would be that is that you have to strengthen section 34. And therefore, the confidentiality has to be maintained, but at the same time, more challenge or more bigger scope than the 34. If not there, if the arbitrators are not trained enough, then probably we'll have to go for transparency and awards will be open. Thank you.
That was obviously an important topic, and this is going to become, in my view, topic for almost the whole day going forward, because this is going to the crux of the arbitration. Now, bringing in the experts sitting here, I think they are patiently hearing all the lawyers, would take away all the time from them. But maybe this best question will get a award as well. There is a sponsorship.
Who will arbitrate that?
MCIA will arbitrate.
Nitin anyway disqualified me on a lighter side because I am a Bachelor of Arts with International Relations, a liberal arts degree. But having gleefully read Hudson's Building and Engineering Contracts in the non-Google days, I think I'll be qualified to talk on real estate contracts.
The point is, can we ask a question as a panelist to get that on?
So there is a prize for a good question also. So please hold on. We'll just take 10 more minutes and then we'll open the floor for questions. So Kartik, I think Kartik and Chaitanya, I think they have been introduced. So this is another, I would not say hot topic in that sense, but definitely a trend which is very important in an international arbitration and which is now becoming more and more common in Indian arbitrations also, as to in appointment of experts in many different areas, right? One obvious is calculation of damages and valuations and claim calculations, but in construction there would be an expert, in maritime there would be an expert, and so on. So maybe Kartik and Chaitanya, maybe you can start, but what's your view and how India is shaping up, or agreeing to the idea or the concept of appointment of experts in an arbitration?
Sure, it's quite challenging to speak to an audience in the last 10 minutes, but I'll try and keep you awake. As always, I think the quantum experts are the lesser models, and they always come last. And whether it is in an arbitration or otherwise, and I think that should change. I would strongly advocate that experts be brought into the arbitration pretty early in the process. At the end of the day, the clients who are probably claimants who are claiming for the sum of money need to understand the magnitude of such loss, and the people who actually help you understand the magnitude of loss is the quantum expert. So I think much more importance and prominence needs to be given to quantum experts. In general, I think that's true of whether it's England, Singapore, or India. But I'll just step back, if I may, and try to sort of give an example as to why quantum expertise is as important. From a quantum standpoint, there are three pillars to any dispute. One is the breach in law, two is the causation, and three is the quantum. And that's how it flows. Now, I'll give you an example. I had a very irritated banker, who's a billionaire in Europe, who walked into our offices in London, and he seemed very exacerbated. And he said, "Kartik, can you do a valuation of a bank?" I said, "Yes, I can." And he said, then he narrated the story. He said, the regulator in this country, I don't want to name the country because it's public, but the regulator in this country has taken certain actions, and this has caused a massive decline in my share price, and I want to claim the loss. So can you value the bank today and attribute the loss to my claim? And I said, hang on a second, I can value a bank, but what you are trying to claim is the damages. So we need to first be ascertain whether in law, in public international law, the actions taken by the regulator was in breach or not. Secondly, I looked at this country, and 34 banks in that country had declined in their market capitalization in the period he was talking about. So do you know whether the actions taken by the regulator caused the loss? So damages assessment is slightly different from just valuing any entity. So you need to be able to understand breach, causation, and quantum, and you need to build the loss framework, and that's where quantum experts gather a lot of prominence. Another case I'd like to say is, why quantum experts are needed. I had this $1 billion HKIC post-acquisition dispute. So we were discussing quite early whether there is going to be a breach of contract or breach of warranty there. A breach of warranty is an expectation loss, it's a future looking loss, or whether it was fraudulent misrepresentation, where the remedy is rescission. These two have different standards of damages. And one needs to be careful to understand that the quantum that you can claim and the framework for losses that you can build under these two legal remedies are completely different. So we were there from the pre-assessment stage, that is when the RFA was filed, right? Quantum experts were appointed and we were helping the clients build their loss frameworks. So it's extremely important for the lawyers to appoint and the clients to appoint experts right at the pre-assessment stage, because we do help in building your framework for breaches, or whether it's any other legal remedy that you're seeking. And lastly, before I hand over to my colleague Chaitanya, one of the things that is extremely important is to understand the magnitude of the claim. And if you want to understand the magnitude of the claim, as the Boeing, if I'm not mistaken, Boeing or Airbus General Counsel was telling on a panel very recently, that he first appoints the quantum expert before even he goes and speaks to the counsel, because he wants to understand, and this is very rare, let me admit. This is a very rare concept, because he needs to understand why is he putting the money on the table for this dispute, and how much is he going to make or lose. And the only person in the room who can help you understand that is the quantum expert. So, and I'm only coming from a quantum standpoint, because that's what I do for a living. But then this is largely true of technical experts. Somebody was talking about germplasm this morning. Can you imagine an arbitrator trying to understand what germplasm is? I mean, that's a joke. I was in an arbitration in NCIA, and this doesn't happen too often. This was a subsea drilling, and the heart of the dispute was a technical issue on subsea drilling, very, very technical, and downstream was a quantum issue. The procedural order had a teaching session, right? Off-record teaching session for the first half of the hearing, where the technical experts from both sides were invited, and there was a closed discussion, and helping the tribunal understand technical issue in a conversational style. It was not adversarial, and they couldn't plead that, so it was without prejudice. And that sort of, I know it's quite mature, we don't see that very often, even in England, but if that sort of teaching sessions can be brought in for tribunals, spend half a day or 3/4 of a day, it doesn't matter, it's expensive, but I think that is very helpful. The other way to do this is to get tribunal appointed experts, of course, but that's an expensive affair. I'll just pause there and hand it over to Chaitanya.
Thanks, Kartik. I think generally what Kartik discusses is how quantum experts are received and used in arbitration. I'm going to take a step back just to sort of discuss the experience I've had of working in India since 2013 as an expert witness, handling questions of quantum to assist tribunals. When I first started this part of my career, there was very limited appreciation for an expert, leave alone quantum expert, even technical experts. There were question marks about what is the need for a technical expert. Why can't the parties provide evidence using their own in-house employees or members to assist the tribunal? Why is it so difficult to convince a tribunal about the technical issues that are in play? Now, one of the things that makes the role of an expert relevant is the issue of independence and neutrality. The expert, in its definition, is playing a role of a participant in the judicial process to assist the judge or the tribunal, and must maintain a position of independence and objectivity. That itself gives them the role that they play in an arbitral proceeding. Now, Kartik mentioned about how damages experts are being used nowadays a lot earlier than they used to. That's quite fair. In fact, to the extent counsels are looking for briefs, especially in the international space, one of the ways they are differentiating themselves is to bring in quantum experts and technical experts at a very early stage, even when they are pitching for the brief to the parties that are in dispute. So that's the level of evolution that has happened over time. The other sort of element to discuss here, I mean, obviously within domestic arbitration, a lot of focus is on Section 74 and the compensation for damages. And that itself has seen a number of jurisprudence evolve, where parties are now able to provide substance behind their claims that are formed for expectations and reliances. Now, just for definition, when you're looking at a breach that results in something that was to be expected in the future, often tribunals in India have struggled with that as it's a consequential loss. But over time, at least in my experience, I've seen a lot of these claims being considered and evaluated and giving awards eventually for breaches. Interestingly, when we first started looking at the role of an expert, especially one that does damages work, it was challenging to convince parties and even counsels to say that an expert is required, leave alone required at an early stage. Over time, I think what has helped is the evolution of certain awards that have come out where experts were involved, and parties have been able to experience the impact of involving an expert witness in the nature of the award that comes out. I'll specifically talk about one case where I think the topic of confidentiality was quite well ignored. This was a case that has a link to Gujarat. It's the Dahej petrochemical complex, which I'm sure many of you would have are familiar with. Now, this petrochemical complex had a part which was to produce high-density polyethylene as the product, and the tender for that was issued sometime in 2011. Now, I'm going to keep this short because effectively the dispute arose from the main contractor who was given the contract pulling out of that contract, and then that contract being given to a replacement contractor. The resultant liability award, because these proceedings were bifurcated, was in the favor of the owner of the plant, and the tribunal ruled that there was a contract that was breached by the contractor who pulled out, and therefore they are liable for damages. Now, this is where parties prepared for the quantum phase of the hearing, and the claims were progressed in the nature of $240 million by the owner of the HDPE plant. Now, through engagement and through the exchange of experts on the other side, eventually the quantum award that was declared was in the amount of 5 lakh rupees against what was claimed at $240 million, because there was enough evidence produced to show that, as Kartik mentioned, the causation wasn't there, as the analysis that was prepared was very different from what was being pleaded in the original case and the award that was issued by the tribunal.
Thanks a lot, Chaitanya. So maybe before we go to the next topic and I think Sanjay also has one comment to make, but any questions, because I'm sure with so many different topics that we have covered, right from technology to appointment of arbitrators to confidentiality to publication of awards and role of experts. Any questions that we would love to have some participation, some comments, even experience sharing is good enough because this is what matters in a conference like this. Otherwise, obviously, we can go on till tomorrow. Yeah, please.
My personal advice to Vyapak that never hand over mic to a person who makes living out of talking.
Hello. Yeah. My name is Arora, and I have this question with pertaining to confidentiality and transparency for the arbitral awards. So, in the case of Halliburton versus Chubb, the United Kingdom Supreme Court, gave a test called the reasonable prudent observer test when it comes to transparency and confidentiality. So, I just wanted to ask that can we adopt this test in accordance with publishing a guideline or coming out with a guideline for publication of arbitral awards? Like if this test is satisfied, then the arbitral award can be published, or if this test is not satisfied, then the arbitral award cannot be published.
Can I just say something quickly before the more experts say? So in an ad hoc arbitration, your agreement arbitration clause itself can take care of that as to which part of the arbitration award can be published or not. And in institution, it is very easy for the institution to make rules. As Nitin rightly referred, for example, the ICC says all awards are publishable unless the parties specifically say that they don't want it to be published, and after every award the ICC writes to each of the parties, please give your declaration on confidentiality.
So, just adding on to that, for when we pertaining to the SIAC, so SIAC's arbitral awards are not published at all. So, when dealing with centers like SIAC, or when we want to adopt something in India, because India is growing and it has to learn from the global perspective. So, can we then have specific guidelines according to which then we can remove the ambiguity?
Yeah, that's the reason why we are debating today. But yeah, go ahead.
Yeah, so in fact, Vyapak answered this query of yours in the initial remark of his. Is that with the registry coming in, where the awards will be registered, we are awaiting what rules will be framed as to the use of that award being registered in the registry. It's not there right now, and in fact we all were waiting, and we got 43A, where it says confidentiality and absolute. So in Australia, the courts held that you cannot read in confidentiality unless the parties have agreed to it. The legislator there overruled the judgment and brought in to say that no, confidentiality will have to be read into an agreement unless the parties waive for it. That waiving portion is not even there in 43A. So you have, as parties, you even do not have a right to waive confidentiality in terms of publication, in terms of use of it, or in terms of anything which you do.
That's your suggestion is correct, and that's the reason why possibly we chose this topic to discuss and debate. That more and more suggestions and discussions need to happen on this before. Again, we have one more amendment which is not relevant for this committee.
Just one level. Just taking it forward, the essential reason why you're asking is to have a presidential value to learn from it, right? In fact, that is the reason why such seminars are important, where people who have actually arbitrated or decided can actually hold and give their views without naming the parties, right?
Maybe we'll take one more question, and then Sanjay, you had one point to make, right? So please.
Good evening, everyone.
We have a mic.
That's fine. I'm Garv Malhotra from Skywards Law. First of all, thank you everyone for this excellent day of conferencing. I'm sure we've all missed this in the last 2 years. My question does tie to the previous question in terms of confidentiality. Now, we spoke about lessons from Singapore a lot today, and I've had the privilege of practicing there. And one thing that I really see missing here is, on a very small point, the practice of anonymization. When we go to court in Singapore in relation to anything arbitration
versus XYZ.
Yes, it's always PQR versus XYZ. We have a simple application for anonymization, and the identity of the parties is always protected. Now, in India, while we have now introduced a provision for confidentiality, it is very hard to get the court, or convince any court, or even the registry, much before you reach the judge, to have a system of anonymization. What, in your opinion, is the way forward? How do we get around that as counsel?
I think in the past there has been some cases where even India has adopted this. We even have confidentiality clubs formed under the Delhi High Court rules. So I don't think, in India I think everything is there, right? We have a buffet of menu everywhere we go. Question is what we select and how we adopt is a question. And if we choose a wrong menu or wrong thing from the buffet, and then we suffer. So I think the whole idea is why we have this, and you can read those confidentiality club rules in Delhi High Court. I think you practice there, and they are excellent. I don't think even international courts have such a great confidentiality club rules as in case of Delhi High Court. So I think we have it. Question is how do we adopt it more and more as we go forward is a question, and in what form and manner, and I'm sure we'll find some solution as we go along.
Absolutely, and bring it harmoniously across the country, not just
that's the challenge.
In fact, just to take your query forward, in the courts, earlier, all of us who have practiced in some 10 years back, even if we are not party to a particular dispute which is being adjudicated in the court, at least in High Court, and you could have easily got the certified copies. Last 5 years, the rules have been made, unless you are party to it, or you apply and satisfy that as to your state, your locus, you will not even get the certified copy. That is one part of it, and every other, that is one thing to say. Then to say that everything is being live telecast in YouTube and in virtual Zoom. In fact, the pleadings are on the screen for everyone to read.
No, but just to add to that, so this is not completely correct. As a matter of form, a constitutional court's record, unless sealed, is a matter of public record. You may not be entitled for a certified copy, but otherwise all copies of whatever is filed in constitutional courts, which is the high courts, are matter of public records, and they are available to each and every one. You can apply, you can take it. Now orders are available on the website. You don't even need to apply for it. Yes, for certified copies, and only in criminal matters you are not given the record unless you are a party appearing or you file your wakalatnama in the matter.
Okay, so we are at 5:30, and I think MCIA has a record that we always start on time and end on time. Well, we have some questions and pointers, but maybe I'll leave it to the audience if they want to hold on longer, but otherwise I'll give it back to
someone has a question. He says no, but there's 2 or 3 hands. The young people has it, somebody from behind.
So formally MCIA has closed it, but if there is one more question, if we can take, okay, if everyone wants to stay here till Sunday, I don't know, but maybe we can take one more question. Kartik? I think gentleman there also has. Go ahead, ask. Behind. So for Nitin, we have closed it at 5:30. We are chit-chatting if you want the point.
My question is...
and you don't need to arrange for dinner as well.
My question is specifically, of course, to everyone on the panel, but to the experts, that whilst you've given examples of your appointments by your respective clients before an arbitration or maybe during an arbitration, what's your opinion about an arbitrator himself appointing an expert? Because that probably, that's my opinion, but however you would be able to throw light on it, that focus on the arbitration, maybe reduce the evidence.
Prachiti, you just need to read section 26 of
They have the power to appoint, but which in India we haven't seen it much in practice.
So that is the whole commitment issue. That's the whole training of the arbitration.
So in their experience, does it help if the arbitral tribunal itself appoints an expert to reduce the evidence, to reduce the time, the cost?
Yeah, actually Kartik had a point, I didn't allow him to speak on this.
So good, now he has the opportunity and I get my answer.
You had a very good point when we had a call before this.
Okay, at the cost of extending this by 3-4 minutes, I'll make the point. So, I haven't seen tribunal appointed experts in London as well, in my experience. But my colleagues have seen in occasional cases. But in my experience with LATAM, which is quite a bit, I have seen, at least in Brazil, almost every case, international arbitration, where tribunals have appointed a appointed expert, which is not good. The reason I say this is tribunal appointed experts come in because they are put in a situation where they need to split the baby, where one expert says 2 billion, the other expert says 0, and that is hired guns. I don't think that is a good system to have. So having tribunal appointed experts, ad nauseum, in my view, is not a good habit. But if it is extremely quantum heavy, or if it is extremely technical heavy, as I said, a teach-in session normally helps, as I have seen, and it's rare, but I think this concept is gathering momentum. Alternatively, I have seen again in rare situations where some of our very senior experts who have been in the business for 30-35 years as quantum experts have been appointed as part of the tribunal. And that brings in a degree and a flavor for, if it's a quantum heavy case, that's helpful. If it's a technical heavy case, as people have already commented, why not get a technical expert to be part of the tribunal? And I think that should be allowed and is allowable, at least under IBA rules. So that's my sort of quick reply.
I had an experience in 1995. We had a dispute with an ONGC drilling issue with ONGC. And at that time, ONGC appointed a retired judge as a High Court. We had appointed a retired judge as a High Court. Luckily, both the judges in their wisdom, because of the technicality with the drilling platform, Bombay offshore, whatever that was, they appointed a technical engineer, a drilling engineer, as the chairman of the arbitration tribunal. And that was a very, very rare occasion, but a very nice thing to do.
Can you also introduce yourself?
Yes, I'm Prachiti Shah. I'm managing partner at Nanavati and Nanavati. Thank you.
Maybe last question.
Just another point, Vyapak, in England, I'm sorry, I stand corrected. The courts at least have single joint expert system on small quantum matters generally. So you get experts appointed by the court to represent both parties. And normally matrimonial issues, you see this very commonly.
Good evening. Thank you for the opportunity to ask the question. My name is Nishith. I'm partner at Govilkar and Associates from Mumbai. I just have a comment more so and to seek your views. Since the pandemic, we have done virtual hearings, and Mr. Nanavati also talked about transcription. Now, that having transcription being expensive and so on and so forth, why not simply have audiovisual recordings of the entire proceedings and make it just simplify the entire process?
We've had that in a few arbitrations.
They are there. All you have to go to.
There are some service providers, I think I saw one of the Just Tech was here, who do this at what, yeah, I think maybe you want to say 1 minute, Prakash.
Yeah, sure, thanks for this opportunity. So, we've got an online dispute resolution platform which can actually completely transform the way, and we've also built a state-of-the-art transcription facility. If you want to ease out that.
I think it's at a very, very comparatively low cost.
Yeah, very, very low cost. So, if you compare it with what you get, and I was telling this to Kartik in the afternoon, it'll be about a 10% cost to that, what you get. Thanks.
Just